Welcome back. Welcome back. Hope you had a nice day. I saw a couple of you at the Supreme Court roundup this afternoon. I was very glad you attended. For those of you who didn't, it's on YouTube. You can watch it later if you like to. It was me and Professor Kelso and my good friend Ilya Shapiro from the Cato Institute, and we had a fun discussion on the Supreme Court. Any questions? Anything in your minds? Okay. All right. Turn this off. So we have a question for you today. This is your question for starting off. The question is this. After Brown versus Board of Education, Plessy v. Ferguson was not the supreme law of the land. That's your question. After Brown v. Board of Education, Plessy v. Ferguson was not the supreme law of the land. That's your question. Who's next?
I think I am.
Brandon, you next? What did you put, my friend?
I put true.
Okay. Why did you put true?
I think for two reasons. One, in the Cooper opinion, Justice Black says it follows that the interpretation of the 14th Amendment enunciated by this court in the Brown case is the supreme law of the land.
Uh-huh.
And two, I think that Plessy was probably wrong. I think it was always, especially in the 14th Amendment, that the case that Plessy was wrong.
Okay. Amber, what would you put?
I said true, but for another reason.
Okay, any other reason?
Plessy v. Ferguson wasn't the supreme law of the land, neither was Brown v. Board of Education. Constitution is the supreme law.
What do you mean the Supreme Court decisions are not the supreme law of the land?
Well, technically, the Supreme Court cannot create law. They can only dictate what the Constitution means.
Where did you hear that the Supreme Court cannot create laws? Does it actually sound familiar to a case we studied in class last semester called Civil Procedure? You know the case we're talking about. If I say it, you'll start cringing. It's not scary.
Erie.
What was holding the Erie case?
Supreme Court is not.
I'm sorry?
Supreme Court is not the.
The Supreme Court cannot create federal common law, right? That was a black letter holding in Erie. The stuff at the train accident was irrelevant. The Supreme Court cannot create common law, therefore they apply the common law of the state where the incident occurred. But it was a much more important case, no one even talks about it. Amber said something that I think was very astute. She said, the Supreme Court cannot create the supreme law of the land. The Constitution is the supreme law of the land. So that raises the question, what is a Supreme Court decision? What does it mean when the Supreme Court issues a ruling? David, what did you put?
I put true.
Okay, what was your rationale?
Because the Constitution is the supreme law of the land.
How do you know that?
Because it says it is.
Says it. Okay, so that's why I have it up here. We have Article 6, right? This is a supremacy clause. Okay? This is a supremacy clause. Make it look bigger. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. So David, why are you contending that a decision of the Supreme Court is not the supreme law of the land?
Well, no, I'm saying that the decision of the Supreme Court is the supreme law of the land because interpret, you know, it's upon the judiciary to interpret the Constitution.
So I'm gonna read this again, right, Aaron? The Constitution and the laws of the United States, which shall be made pursuant thereof, in all treaties made, shall be the supreme law of the land. Where does it mention Supreme Court decisions?
I guess in part where it says the Constitution, it says the Supreme Court is there to interpret.
Says who? Says who? Who said that?
That the Supreme Court is intended to interpret the Constitution.
Yeah, where do you get that from?
I thought it was in the Constitution.
It's not. It's not there, trust me, Brett, it's not there. Take my word for it, right? Where do we get this idea that Supreme Court decisions are the supreme law of the land?
Because they're the laws that were made in pursuance.
Well, who makes laws? Which branch of government makes the laws?
Congress makes them.
Yeah. Does it say anything about courts there? Well, it does mention judges. What does it say about judges? Judges are mentioned.
The judges in every state shall be bound thereby.
What are those judges bound by?
Whatever Congress said.
Supreme law of the land, which is the Constitution and the statutes. So Jason, I ask you again. Was Plessy, this is Amber's point, I think, was Plessy ever the supreme law of the land?
Yes. Because I think it's the same, the judges have to interpret the Constitution.
Where are you getting that from? I'm looking at supremacy clause. Where does it say that if 5 judges of the Supreme Court agree, that's the supreme law of the land? It's right up there. It's right there. Hasn't changed in 220 years. You're really thinking hard. Tell me what you're thinking about. Like, there's a lot.
Well, no, right, I mean, so, you know, we determined our court system, right? And in our court system, we've said that there's a structure. So yeah, there are judges, but there's judges within the structure. And we've given, society's given judges the job of interpreting what's the Constitution.
Society gave judges that power. Where does it happen? I've read the Constitution, it's not in there.
It's not in the Constitution, but it's in how we've acted. And we've talked about this before. What's the power of the court? And the power of the court really is what we give and what we allow.
Very good. Okay, very good. So, all of you have more or less, I think, hit the points I wanted to hit here. We simply take it for granted that when 5 judges write an opinion, that's now the supreme law of the land. And today, that's almost uncontroversial. But that really wasn't the rule until we got to Cooper v. Aaron, which I think 1 or 2 of you mentioned. Marbury doesn't get you there, right? The wrong answer is Marbury. All Marbury held is that the courts have the power to set aside unconstitutional legislation. But it never held that decisions are, in fact, on the same level as the Supreme Court, as the Constitution itself, right? The Constitution comes first. Then you have statutes and you have the treaties. Those are supreme law. But it says nothing about decisions of the Supreme Court. Now, why am I giving you all this? Aren't we supposed to be talking about Brown? Like, why am I giving you all this stuff, right? The lecture on Brown, Brown 2, Cooper, are as much about the supremacy of the Supreme Court as they are about desegregation, right? These cases are as much about the power of the Supreme Court as they are about desegregation, right? I can teach you the holding of Brown in 2 seconds. It's not hard. But the important story is what happened after Brown and the effectiveness of the judiciary as a whole in actually implementing it. So I often ask you the question, what happens if a court orders something and people say, I don't care? That more or less is what happened in the years following Brown. Not exactly, for reasons I'll discuss. There's some nuance there. But that, in the general sense, is exactly what transpired. So this case, Brown, is not simply about whether Plessy was overturned or whether it was good law or not. It goes far beyond that in defining the modern day powers of the court to bind people, not only the parties before them, but also to bind other parties who are not before them. Now, did all of you get the supplement and you see the part I signed outside the book? Okay, good. What's that? Yeah, it was in the book. Yeah, that was in the book. I'm sorry? That was the thing? That was where you say it very quietly?
Yes.
Think I'm not going to hear it? Yeah, I got really good hearing. It's really bad for you. I'm sorry. But I'll do my best. So, any other questions before we get started? All right.
So is it true or false?
Let's see what people put. I don't know. I'm deliberately not stopping the poll because when I stop the poll, the results show up, right? You don't see the results while the thing's running, do you?
No.
Oh, let's see what we got. Drum roll, please. So most of you put true. I think it's true. I think the answer to this question is true. I don't think Plessy was ever the supreme law of the land. And I don't think you ever got, not until Cooper did the argument was made that a decision of the court is supreme itself. Okay? So let's start with Brown. Brown is one of those cases where you know it by one name, right? You don't even need to say Brown versus the Board of Education of Topeka, right? You don't even need to say the rest of it. Just you say Brown, and people know what it means. Even if you're not in law school, people know the name of this case. People probably don't know who Brown actually is. So, you know, I love pictures. This is Linda Brown. She was a third grader. I'm sorry? I'm just going to ignore you. Okay, sorry. Unless you raise your hand, I won't call on you, okay?
Okay.
Sounds good. This is Linda Brown. She was a third grader who lived in Topeka, Kansas. And at the time, Kansas law required her to enroll in a segregated school. There was actually a school reserved for white students, which was much closer to her. The segregated school was much further away. This is Brown's family. Linda's sister was a little bit older, and she was also involved in litigation. By the time the litigation went through the course, she had already graduated at the middle school, so she never actually benefited from this decision. This picture I love because it's all the plaintiffs sitting there with their parents. What you have to understand about this case was it was as much a legal challenge as it was a PR challenge. What do I mean by PR challenge? The purpose of this litigation was to make people understand that having integrated schools was not going to be the end of the world, right? And letting these kids into your school is not going to screw things up. So they deliberately recruited, and I say this deliberately, very cute kids, right? Who are very likable, very relatable. They take pictures. They were on the cover of Life magazine, which was a very prominent magazine at the time. And the idea was, what?
She's so cute.
Yeah, I know, these kids are adorable. This was done very deliberately. So the strategy was in the early days of the litigation to focus on professional schools, right? I think I mentioned this a few weeks ago, but there was a case called Sweat v. Painter, which involved segregation at UT Austin Law School. And rather than integrating UT Austin Law School, they said, aha, we will create another law school for African American students. They made TSU, Texas Southern, which is now named Thurgood Marshall. And the Supreme Court said, wait a minute, you can have separate law schools, but that's be equal. And they said, guess what, TSU, you're not equal, right? It's not as elite, the professors aren't as good, it's not as good facilities. So the Supreme Court said that UT Austin Law School had to integrate. So that was like the first phase, professional schools, medical school, law school, etc. The next wave, after they won some victories, by the way, when I say they, I mean the NAACP, Thurgood Marshall, and some of the other lawyers. After they won the first round of cases, they said, all right, we're going to schools. And they recruited children, and really it's the parents of the children. They recruited children, at school throughout the country. And, these kids are pretty brave, putting themselves out there and putting their faces on magazines, right, where they can be recognized. And they recruited children from across the country. Their names were from the front row. This was Vicki Henderson, Donald Henderson, Linda Brown, James Emanuel, Nancy Todd, Catherine Carper, and the back row was Zelma Henderson, Oliver Brown, Sadie Emanuel, Lucinda Todd, and Lena Carper. I have a picture of them in the third edition. It wasn't cheap, believe it or not. The way it works is all these pictures in your book, they actually cost money, and they eat out my royalties, but I think they're worth it. So I actually, we bought a picture of the students, which will be in the next edition of your book. I think we have this one, which I really like. This is Monroe Elementary School in Topeka, Kansas. You can actually go there. If you're ever in Topeka, it's a museum. You can actually walk around. I've not been. I would like to go at some point. This school is about 21 blocks from where she lived. If my recollection is correct, the white school is only a few blocks away. So she argued, hey, why am I walking 21 blocks from the school like 3 blocks away that I could go to? This is it. And there are signs inside. If you see, it says white that way, colored that way. And there were actually all these signs pointing left or right, depending which race you were. And this was an actual school, and it's now a national park. This is a photograph from inside the classroom back from the 1950s. Here's another photograph I have. Let's see. And this was Sumner Elementary, which was much closer to where Linda lived. Okay. So this case again was brought with plaintiffs from a number of different states. It was South Carolina, Virginia, Delaware, Kansas, and the District of Columbia, getting all 5 of them correct. All of these laws were challenged in the lower courts, and consistently the lower courts ruled for segregation. Why? They said they were bound by Plessy, right? Plessy was indeed the law, had been the precedent for 70 or 80 years at that point, and they were bound. Only the Delaware Supreme Court, you don't think of Delaware, do you, right? Delaware had segregated schools. And only the Delaware Supreme Court found that segregation was unconstitutional. The case was appealed to the Supreme Court in 1953. And it was first argued in the spring of 1953. After the first argument, the justices were unable to decide the case. What do I mean they were unable to decide the case? It wasn't unanimous in that there was going to be some dissents. And the sense was it was so important to have a unanimous decision here that if there were dissents, it would give motivation to the segregation, saying, aha, this is illegitimate. Let's just get a couple more votes in the Supreme Court, flip it the other way, right? But then something cosmic happened. Chief Justice Vinson, who opposed striking down the law, died. He died in September of 1953 unexpectedly. I think it was a heart attack. And President Eisenhower made a recess appointment of Earl Warren to be the new Chief Justice. Warren was the governor of California, a Republican, but who had extensive political experience. After Warren was appointed, they had the case re-argued. And Warren insisted on getting a unanimous judgment, no dissents. And over the next few months, he twisted enough arms to get a unanimous 9-0 decision. But one of the consequences of a unanimous decision is, how shall I say, the narrowness of the case. When you guys read this, is this what you were expecting? No. Amber, you're shaking your head no. Why was this not what you were expecting?
Just really short.
Yeah, really short. And did it say much?
No.
Did it make a lot of pronouncements about equality and justice and truth and American way and everything? No. No, I think that every year students come to me and think, Josh, wow, that was underwhelming, right? I was expecting, Brown, right, this, 80-page magisterial opinion about the law and equality and why segregation is evil. None of that. So one of the reasons why the opinion is so short, or I'd say concise, is they didn't want to lose anyone, right? They didn't want to fracture any of the justices off on dissent. So the opinion didn't do much, right? So, who am I up to? Are you next? Yeah. Okay. So, Brittany, just give us the court's general analysis, right? how did they go about resolving this case? Again, it's a very precise route that they took.
So one of the first things they did was they kind of shot down Plessy versus Ferguson by saying that it doesn't apply when it comes to public education.
Oh, what a good answer. Did they overturn Plessy in its entirety?
No,
No. Where did they say that Plessy was not applicable?
in public education. That's all they wanted to say.
Exactly. Now listen, why do you think they narrowed the scope of the holding to just public education?
I guess they narrowed it down because it hadn't been addressed before as far as separately equal.
Well, you had Plessy. Plessy was about train cars,
that,
right?
That was about transportation, not the education of the citizens, which they were trying to better.
But let me ask the question differently. Why did the court just say we're overruling Plessy, period, done, end of sentence? What would the consequence of such a decision have been? Yeah, if they had just said, starting today, Plessy's now overruled. Was never good law, we disagree with it, done. What would that decision have resulted? What would have happened
I
in the
think
world?
mad chaos.
Okay, chaos, good, but specifically, what would have been the legal consequences of overruling Plessy in its entirety? What other sorts of laws would have been in doubt had Plessy been overruled? Let me ask a question like that.
14th Amendment.
No, I'm talking about state statutes. Kelsey, I think it's that? Jim Crow, yeah. Everyone understand that, right? The Jim Crow, which is it's an umbrella term for the entire system of legalized segregation, meant in a lot of southern states, and in some northern states, it wasn't just south, Delaware was in it also, there were extensive laws which separated the races, not just in schools, in places of public accommodations, government buildings, right? Anyone ever see the movie To Kill a Mockingbird? Remember the courtroom scene? Courthouses were segregated, water fountains, the entire list, right? If the court went ahead and said Plessy was wrongly decided and was overturned, all of those laws would now be in jeopardy, and lawyers could run to court and sue to stop every facet of Jim Crow segregation. Right? So everyone see that much, right? So the court stopped short of overruling Plessy, and Brittany's right. They only ruled in the context of public education. Okay? Now, Cortland, let me ask you this question. Why did they say that Plessy was wrong in the context of public education? What about it?
They talked about how modern studies confirm children have negative experiences when they're segregated.
Yeah, let's talk about this for a minute. Has anyone, I think I have a picture of it somewhere. I don't have it here, I'm sorry, it's in the next book. Has anyone ever heard of the doll test? Anyone? Trying to tell us what this is? Here, let me get this here good here.
It takes a dark skin doll and a light skin doll, and it asks children, like, which one do you think is the good one? And oftentimes they have more positive association with the person, with the doll of the lighter complexion than that of the darker complexion.
Yeah, perfectly stated. But back there was a wrinkle. So what happened was there was a test done in the 1950s, right? There's a picture of this in your new book, you'll have a picture, I have it here, where a child was shown a black doll and a white doll, and he said, which do you prefer, right? And they ran this test over and over again. And more often than not, both children picked the white doll. But then they asked children who went to segregated schools. And here's the key. The kids in the segregated schools were more likely to pick the white doll than the black doll. And the resolution, the conclusion from this research is that the segregated schools breed inferiority, right? They tell a person that you yourself are inferior and prefer the white doll. And this worked doubly, not just for the black students, but also the white students. That for white students to see, oh yeah, that kid lives across the street, goes to this other school, that means I'm better. So this is footnote 11. Everyone knows that footnote 11 in your text, right? It cites like all these articles, and you're like, wait a minute, those aren't cases, those are articles. These were all various pieces of what's called social science research that suggested that having the segregated schools actually breeds this inferiority complex. And that's one of the reasons why you have segregated schools. If you teach someone from the youngest age, 5 or 6 years old in kindergarten, that you go to this school and your neighbor goes there, you're better than him, that instills a person, right? That makes a lasting impression on children who don't really know one way or the other what's going on. So the court's decision was in large measure driven by this social science research, right? Now, Eric, the other part of the decision that they were asking about is what you might call history, right? What maybe Justice Scalia would call originalism, right? How would the framers who ratified the 14th Amendment have understood segregated schools? And what does Chief Justice Warren say about history here?
It just says that you can't necessarily look back at history because of how things were historically set up at the time the 14th Amendment was ratified, that white children went to private schools and black children were largely uneducated just in general. And so you can't really look back and talk about the historical content of it because it's just not there.
So, Eric, let me ask you the follow-up question. If the history of the 14th Amendment doesn't tell you one way or the other, why shouldn't the court stick with Plessy, which was decided within maybe 15 years of that amendment, right? In other words, if we can say that history doesn't really give you an answer one way or the other, why do modern stuff? Why cite psychology articles from the 1950s when you have a decision, an almost unanimous decision from the court within a couple of years of the ratification of the 14th Amendment? Well, if the history is inconclusive, is that the answer? Okay, then we keep Plessy.
No, I think if the history is inconclusive, then it doesn't support Plessy necessarily. It still needs, if it's inclusive, then it still needs a decision.
Okay, so Martin, what do you think? If the history doesn't give one way or the other, then why can't we just stick with what we've had for 80-something years?
Really, I feel that coming up with any justification is a post hoc rationale for what they knew was right. You know, they're looking for a way to justify what they feel they need to say.
So the Supreme Court's job is to do what's right. Is that what they're there to do what's right?
It's not what is written for them to do. No.
Who's to decide what's right and wrong? You walked right into this. I'm sorry, but you said their job is to do what's right. So I'm asking you, how are they to know what's right and wrong? Is that what a judge's job is?
I mean, that's inherently what a judge's job is. They're there to arbitrate when two people can't figure out a situation.
According to what? Arbitrate according to what? You know the answer. You don't want to say it. You know the answer.
Social contract?
Law. You give me social contract. The law. And in this case, the law is the Constitution. So, Bahara, I'm going to play up Martin's question. You're stuck with it. I'm sorry. If a judge knows that segregation's wrong, but the framers of the 14th Amendment permitted segregation, then what's the answer? They say segregation's wrong, it's evil. But the framers of the 14th Amendment permitted segregation at the time. No one objected to this.
That's a hard question.
That's why I asked it. Blame Martin, not me.
I have no idea. But can I say one thing?
Please. Please say something, yes.
Does the Painter case have anything to do with it? How there was cases before this?
Yeah, but maybe Sweat v. Painter was wrong also. And in fact, to the contrary, Sweat v. Painter applied Plessy. What the TSU case, the Texas Southern case, said is separate is you can have separate but equal, but they're not even equal. They're unequal. So I mean, Sweat v. Painter was an application of Plessy. It basically reaffirmed it in a way. You don't want to take a stab at this, right? Yeah.
Well, didn't in the words of the Constitution, the framing of it, didn't it say that it was not meant to be? I'm trying to explain. Like it was meant to be flexible to the involvement or to.
Who said that?
Not flexible, but it's not.
I know what you're thinking of. It wasn't the Constitution. Who said that?
It wasn't.
Which opinion you're thinking of?
I know.
I know you do.
I can't think of the name right now. Off the top of my
Who
head.
knows what opinion she's talking about? It's got to be a couple. There's a couple choices. That the Constitution is meant to endure for the ages. Yeah, say it. McCullough, Maryland. Bingo, exactly. But John Marshall said that, not the Constitution.
Oh, sorry. But it was referring to the Constitution. So, yeah. I mean, even if there's not history, you don't even see.
Yeah, of course. No, I super pass.
Even if there's no history of it, because the Constitution was meant to endure feel free to finish it off, but for the ages.
So can judges update the Constitution even when the Constitution is not updated?
No, the Constitution can only be amended, right?
So, yeah, so the question is this, right? What if we can show definitively that at the time of the 14th Amendment, people understood that schools should be segregated? In fact, there were segregated schools in the District of Columbia at the time of the ratification of the 14th Amendment. What if the answer is just the framers of the 14th Amendment were okay with segregated schools? What if that is a clear historical answer? Actually, then what do we do? Is Brown wrong? Let's just say hypothetical. Maybe I'm right, maybe I'm wrong, but at the time of the 14th Amendment's ratification, schools in D.C. were segregated. Does that mean that then this is an open and shut case that Plessy was right? Martin's right. Maybe segregated schools are wrong. They're evil, right? But what if the law commands to have this?
Well, we've had, just because the law commands it doesn't mean that it's...
So if the law is wrong, what's the remedy? If the law is wrong, what's the remedy for that? If the Constitution doesn't give you what you want, what's the remedy there?
Change it.
You amend it. But can the Supreme Court itself change the supreme law of the land?
The Supreme Court.
Quit while you're ahead.
I mean, didn't they just do that actually in the Obama period? Isn't that what happened?
Quit while you're ahead. They're not supposed to, but they do. Case, your hand was up a minute ago.
It just comes down to the interpretation.
No, but I'm saying there's no interpretation. I'm giving you definitive historical evidence that at the time the 14th Amendment was ratified, the framers said, oh, this doesn't require schools to be integrated. Of course you can have separate schools, right? I'm giving you, like, in stone, chiseled, right? I'm not, take my question as it is. Brandon?
I would say it was a huge blind spot.
Then if it was a blind spot, what's the solution to that blind spot?
Well, you change it.
How?
Well, like you were saying, through amendment.
Or
you take up a similar case again.
And hope the judges change it.
Right.
Right. So all of you are more or less circling in the same instance, right? And I'll summarize the debate a little bit like this. What the court's saying here is basically, history doesn't get us the result we want, so we're going to do it anyway, right? We can't look to history to get where we want to go, so we're just going to put that aside for a minute, and we're going to cite social science journals. We know that this is right, and if history supported us, my God, we'd cite it, right? If there was some history they could have cited, you know they would have cited it, because they want to ground their ruling in some sort of historical legitimacy. But they didn't have it. They said, we don't have it. So instead, they go down this other road of citing social science journals. Now, they were probably wrong. There's actually a pretty decent argument that the framers in the founding generation of the 14th Amendment would have understood school segregation a little bit differently. And if you're interested, there's an article by Michael McConnell, who became a federal judge, after your reading. I didn't assign it. It's really long. I would not do that to you. But if you want to read it, read it. And there's a response by another guy, Michael Klarman, also a historian, who disagrees with him. So there's a credible argument that you can support Brown by looking to the original understanding of the 14th Amendment. I'm not endorsing one or the other, but Chief Justice Warren did not have that evidence at his hand. If Michael McConnell was clerking for Warren that term, I bet you have a great originalist opinion, but that wasn't the case. Yes, ma'am?
So would you say as a summary that where history is inconclusive and the law is morally wrong, can you change the amendment?
I would absolutely not say that, but Chief Justice Warren would.
That's kind of came up, I think.
Yes, duly noted, right? Not Josh Warren. We all know who matters here, right? But I think Adiyami summarized it quite well. If you didn't hear, she said, say it one more time, you phrased it quite well, I think.
Where history is inconclusive and the law is morally wrong, it can be changed to amendment or new precedent law.
Right, so Adiyami's point, I think, is actually well taken. If the justices say that segregation is wrong and nothing in history supports a change, you just make it up. You adapt the law, you evolve the law, use whatever word you want to use, update the law. Now, how do you amend the Constitution? It's hard. You have to have 2/3 of the states or 2/3 of both houses agree to the language, and then 3/4 of the states have to agree. Does anyone think in 1953, 75% of the states would have agreed to eradicate segregation? Of course not. I don't think we had 50%. I think it'd be below that, right? I only gave 50% there. So a Supreme Court decision is a lot easier. You need 5 votes, or in this case, we had 9 votes. But I just want you to dwell on that point for a minute. The court almost instinctively turns to history first. Says, look, we really want to strike down segregated schools. We really wanted there to be an answer in history. We couldn't find that answer, so we're just going to ignore history here, right? We're just going to ignore it and find some other reasons why. So what did they turn to? They looked to other cases, like Sweat v. Painter, and some of the other decisions, which again were applications of Plessy. I mean, there's an irony there. They're citing cases that applied Plessy to overrule it, right? Sweat v. Painter was an application of Plessy. They cite social science about the importance of education. They cite these the doll test study, right? You look at footnote 11. And they say, based on this social science, people in the 1860s did not know what we know today. I mean, think about that for a second. They're saying, what we know today about science, they didn't know back then. Therefore, any language in Plessy contrary to this finding is rejected. The reason why Plessy was rejected is because we know stuff about science today they didn't know back then. By the way, the science isn't exactly fixed in stone. There's actually some science that suggests that having education where races are separated in certain contexts may actually be beneficial. And they're actually reinforcing benefits of that. In fact, some law schools are actually experimenting with effectively racially segregated sections where they have one class where people only one race are inside of it. I'll leave that aside for now, but there's signs that maybe the Doll's test wasn't fully inclusive. Not saying public schools, but some colleges are experimenting. Yeah?
That's weird.
Berkeley. Yeah, if you Google it, this was maybe 2 years ago. It was at UC Berkeley. It caused a pretty big stir. Yandre.
I think the difference there would be that it's probably opt-in. The force, no?
The reason why the story blew up is they basically signed people out asking them. Yeah, like it was like a program. It was a just Google it, you'll find it. I forget the specifics, but it was like basically the schools assigning people to various. They were like small sections, like maybe 10 or 11 people. It's not like a 80-person section, like a small seminar section, and it would actually divvy people up based on race. It blew up. It was a big story 2 or 3 years ago. Yeah, Brandon.
It seems like the court has a hard time just saying it was wrong. I mean, do they ever come out?
Yeah. Did anyone else notice that? Why don't they just say it was wrong?
Do they ever come out in an opinion and say,
yeah,
we were just wrong on this issue?
Sometimes. Yeah, Emily.
Well, from your lecture over the lunch break, someone, I can't remember who said it out of the panel, but someone said like each new appointment of a justice creates a new court.
Very good, Justice White. Very good.
So why would they say, yeah, we were wrong when the justice might not even have been a part of that decision?
Well, yeah, but that's a fair point, right? Can you criticize a decision you weren't part of? So occasionally the justices say that opinion was wrong, we're overturning it. And I think of West Coast Hotel v. Parish, right? Where they said Atkins was wrong, we're overturning it. Here, again, I don't think they can come out and say Plessy was wrong, because that would have put a lot of other segregation laws, Jim Crow, in jeopardy. Adam?
The whole decision makes me kind of laugh, because in a lot of America, especially small town Mississippi and other places, segregation is alive and well still today. I mean, my wife comes from a small town in Mississippi that just this year desegregated, and the whole town is up in arms. It's really pretty funny. You know,
well,
70 years later.
That brings me to my next point, right? Actually, thank you. It's a very good segue to my next point. So the court holds, right, and this is the holding of the case, in the field of public education, the doctrine of separate but equal has no place, right? That's the black letter holding. In the field of public education, the doctrine of separate but equal has no place. But that's not the end of the case. That the part of the opinion that I call the okay, so now what, right? We just said this great thing about the separation, segregation is not equal, right? Now what? I think Adam's point answers my next question. Did the court order that all schools must desegregate immediately? No, not even close, Adam. What did they order instead? What was the actual outcome of Brown Part 1? Not Brown 2, just Brown Part 1.
Constitutionality of segregation in public education.
At the very end. You'll miss it. If you read it quickly, you'll even miss it.
Okay.
What's the actual outcome, the order of the case?
Basically, these cases present problems, considerable complexity,
Yeah, big problems, yeah. Then what? Keep reading. Anyone,
They announced that such litigation denial of protection from laws.
okay, Emily, yeah,
They
you.
restored it to the docket.
What does that mean? They restored it to the docket.
They're gonna argue it again.
They're going to argue it again to decide what?
Remedy.
Remedy, right? You've never seen a Supreme Court case like this, right? And you've been in my class now, what, 2 months? This is class number 20, by the way. We have 28 classes. You guys are almost done. We're like more than almost 2/3 done. Yeah, oh, thank God, right? Yeah. This is a decision you've probably never seen before like this, where they say, look, we just announced a segregation and denial of equal protection laws, but we're not going to decide it now, right? We're going to argue it again. And we want to decide what the remedy should be, right? They say, should a decree be issued to allow these children to be admitted to schools, that is right away, or can a court permit, here's the key language, effective gradual adjustment, right? That's language here. Effective gradual adjustment. And then the next question number 5. Should the Supreme Court handle this, or should they send it back down to the lower courts to handle on a case-by-case basis? And they basically invited the Attorney General to participate, and state AGs can participate. And that's it, folks, right? That's the end. Right? So when you see this headline, right? I think I have it here somewhere. Right, so the newspaper headline says, it's hard to read, High Court bans segregation in public schools, right? This iconic photograph of a girl sitting, by the way, that's not Linda Brown. If you Google it, you'll say, oh, it's not Linda, it's someone else. I think her name is Leslie Hunter, but I forget the first name. It's not Linda Brown. You have this iconic photo, right, with this newspaper, High Court bans segregation. It didn't do that exactly, right? It didn't make any order. And you see this picture of, Thurgood Marshall and his colleagues celebrating outside the Supreme Court. They got a victory, but it was not over. In fact, it was more or less just beginning. So, Brittany, let's do Brown 2, though. I'll come back to Bolling v. Sharpe. It's a little bit, that's like climactic. Let's do Bolling first. Let's do Brown 2 now. What happened in Brown 2? By the way, when I say Brown 1 and Brown 2, there were 2 cases of the same name. And when you have that, the Supreme Court often gives numbers, right? So Brown 1 was the first decided case. Brown 2 was the second decided case, just so you get the terminology straight. So Brittany, what happened in Brown 2?
Well, it's been going back up again, obviously.
Good.
They were inviting the Attorney General and everything to present their views on a question for the different states.
Good. By the way, remind us, which states were involved in this case, do you recall?
Florida, North Carolina, Arkansas.
Well, no. Those were amicus, right? Which states were actually parties to the case? Which laws were being challenged in this case?
I'm not sure.
Yeah, Brittany?
Kansas, South Carolina, Virginia, Delaware, and District.
Yes, ma'am. 5, right? You had Kansas, South Carolina, Virginia, the District of Columbia, and Virginia, right? You have 5 states, or 4 states in the district. So those are the only parties actually who were involved in the case. What the court did was they invited what are called amicus briefs, or friend of the court briefs from a bunch of other states, right? And the question was, I think Brittany was getting there, is how should we go about addressing Brown 1, right? How should this be put into play? So Brittany, what was the court's ultimate conclusion of how to handle the Brown 1 decision?
That they can consider some of the problems, but it's kind of a local issue.
Okay, good. What does it mean it's a local issue?
That it needed to go back to the states.
Well, go back to the states or go back to where?
The districts.
The district courts, right? So the remedy was, okay, we Supreme Court, we just made this broad ruling. We are not going to supervise the desegregation process. We're going to send this back down to the lower courts in D.C., Virginia, South Carolina, and Kansas, right? To enforce and implement this order. Okay? And the court says a few things that, in hindsight, and actually Adam's comment alludes to this, that are, he used the word funny, I'll use the word perhaps ironic, maybe a more precise word. Defendants must make a prompt and reasonable start. Okay? The Supreme Court will retain jurisdiction. How long will they retain jurisdiction? Adam mentioned like 2017, right? Some courts are still having jurisdiction over desegregation cases. And then you have this sentence, I want to read it to you. It's at the very end. It says, we remand and the district court will enter decrees consistent with this opinion as are necessary and proper, oh, there's that language, as are necessary and proper, to admit to public schools on a racially non-discriminatory basis with all deliberate speed. With all deliberate speed. China. Right, right? I had that once where I congested left ear, but not my right ear. So I think it was this semester, wasn't it?
Yeah.
It's a damnedest thing, right? It's the weirdest thing. China, what does that phrase mean, all deliberate speed? What's it? It's at the very end, like if you read it quickly, you blink over it. What does that phrase, all deliberate speed, mean?
I would interpret it as, and I think what their meaning is, the local districts are going to decide what's best for their own areas, as opposed to the Supreme Court giving them strict deadlines to abide by.
So the phrase deliberate speed, how do you define that?
Their time, at their time.
At their pace, right?
Yeah.
So how long is that going to take?
Exactly, as long as they.
Decades, right? So what the Supreme Court is basically saying here is, we're okay making this broad pronouncement, but we recognize this is going to take some time, and we're not going to order that all schools immediately desegregate like tomorrow. They said, we're going to send this back down to the lower courts, and they're going to decide at their pace, at their time, how long this is going to take. And that was a holding, right? Again, underwhelming. You see this girl at the newspaper, right? The headline exaggerates what actually happened. I think I read somewhere that this was an NAACP report that in 1954, do you know how many schools actually desegregated in the South? 0. Not a one. 0. Not one actually desegregated that year. So the speed question. Now, Jay, let me ask you a follow-up question to that. When they say go back down to the lower courts, which courts are they talking about here? Which ones? I keep asking this question very deliberately. Which laws were involved in this case? You said a minute ago.
Oh, Delaware.
Okay. Virginia, yeah. So actually, Delaware, the state Supreme Court already struck down the law, so it didn't go back down to Delaware. But it was Virginia, South Carolina, Kansas, and District of Columbia, right?
So those courts in those.
Right. So Jay, here's my question. Were the schools in Arkansas bound by Brown? That's your question, right? Were the schools in Arkansas, the laws in Arkansas requiring segregation, were those controlled by Brown?
Yes and no.
Okay, give me your answer. Yeah.
Yes, because that was, the judgment was directly for those district courts. However, they still had their own, they still acted on their own case. So it really, it wasn't, they didn't forcefully say, at this time, every school in Kansas, you have to desegregate. They didn't do that. They allowed them the leeway in order to do it on their own time.
So your reading is, the Supreme Court said, okay, 4 states, Kansas, Virginia, South Carolina, you have to do it in your own terms, but also other states as well? Was the Supreme Court's order in Brown to direct those 4 states, or all 50?
Well, it says that accordingly reversed, and the cases are remanded to the district courts to take such proceedings and enter such orders or decrees consistent with this opinion. So that line is seemingly is that it's for those particular states.
You're right. Everyone hear what she just said. She's exactly right. If you ever want to know what a case actually does, read the last line, right? It's like a cheat. If you read the, and Jay said it exactly correct. The very last sentence, the very bottom of the page, you probably skipped over in your outline, right? It's like, we're remanding these 4 or 5 cases to the district courts, and that's it. so then the question arises, right? And this is shifting to Cooper. I promise I'll get back to that Bolling in a few minutes. This raises the question of Cooper v. Aaron, right? Were other school districts in Little Rock, Arkansas, in Tennessee, Mississippi, right? Were these other school districts bound by the Brown decision?
I just believe that they were bound because it was given out that way, but it was the legislation in those 4 states and 1 district that made them actually make some moves right away. Not necessarily right away because some of them still dragged their feet, but because of the legislation that was already pending, they had to do certain things. But it had given everyone else time to know we're moving towards this.
Case, you want to add something?
Abraham Lincoln would say that.
Oh, what did Honest Abe say? Let's bring us back to Honest Abe. I was going to get there in 2 minutes, but you cut to the chase.
There weren't a party to the case.
What did Lincoln say about Dred Scott? Remember I told you this would happen. I warned you, and I gave you a preview in case you remember it, so very good. Right? It's the antenna giving you a connection to the past, right?
Yeah.
Sorry, that's me. I like it's good.
This is fell my face.
It's cool, right? So what did Lincoln say?
It's not cool.
I think it's cool. Oh, come on, Andrew. What are you doing to this guy?
There you go.
It's cool, man. It's cool. So what did Lincoln say about Dred Scott, right? What Lincoln said about Dred Scott is this, that it's a decision of the Supreme Court. It got 5 votes, I think it got 7 actually. But it was a case between Dred Scott and Sanford, right? 2 parties, that was it. And Lincoln said we should limit it to those parties. The federal government was not a party to Dred Scott, therefore it's not bound by the case, and therefore the Missouri Compromise was valid, right? You can have the elimination of slavery in the Northwest Territories, right? The argument here by the southern states is Lincoln's. Who was a party to Brown? It was Brown and Topeka Board of Education. It was, I'm drawing a blank on the other kids' names, but the other kids versus South Carolina, the other kids versus Virginia, right? And actually, it wasn't just versus Virginia. It was a school district in Virginia, okay? Linda Brown wasn't suing the state of Kansas. She was suing the Topeka, Kansas Board of Ed. So she wasn't even challenging Kansas City, right? She wasn't challenging other cities. So the legal resistance, or what was called the massive resistance that emerged following Brown, was premised on this idea that we have to read Brown as narrowly as possible. Now, I'm not trying to whitewash this in any respect. These were racists, but they were racist with a theory. And their theory, here's a newspaper headline, and their theory was that until a court tells us that we are bound by an injunction, we are going to resist integration. And this is why Adam's question, you had a district by district, city by city war, where each district basically waited, kicking and screaming, dragging their feet, whatever word you want to use, to resist the the integration of their public schools. Now, some schools actually resisted in a very strange fashion. It's in the book. I don't have it here. I'm sorry. This is a related example. Does anyone know what this is a picture of? Well, it was a swimming pool. What happened to it?
They filled it.
They filled it with cement. Cement pond, right? Why did they fill it with cement?
Rather than segregated.
So this was from, I think it was from Jackson. Yeah, from Jackson, Mississippi. Rather than integrate a swimming pool, they just filled it with cement. This happened to school districts also. The Prince William County, Virginia school district, rather than integrate, simply shut down the schools for a couple of years. And what they did was they gave the equivalent of vouchers to people to let them go to a private school, so kids got their education. Towns in Arkansas went without public schools for years. Like you had a lost generation. People just never graduate high school. It was like, what was that?
That explains so much.
I like that. You're just on a roll today, man. You're giving Case a hard time, you're giving Arkansas a hard time, man. So, a lot of these jurisdictions resisted the integration, but the part I want to focus on is what gave rise to Cooper v. Aaron. And I think I've talked about this case before. Here it is. By the way, anyone from Arkansas? No, that actually demeans your entire state. Oh, here it is, the picture I want to show you. So this case is actually probably one of the most significant cases in Supreme Court history. Because this is the case that established the principle that the Supreme Court's case law are the supreme law of the land. Right? Cooper v. Aaron established that principle, that the cases of the Supreme Court are the supreme law of the land. It had never been said before. They cite Marbury, but Marbury didn't say that. So this established that principle. Yes, ma'am? Please. Cooper established the principle that the Supreme Court's decisions are the supreme law of the land. Right? That's where it comes from. It's not Marbury, it's Cooper. This is the notion of what's sometimes called judicial supremacy. You'll see that judicial supremacy. But it also established another principle, that the Supreme Court's decisions are binding not only in the parties to the case, but in everyone. Right? That the court's decisions are binding on everyone everywhere. Not just the parties bound, but everyone. This is saying Lincoln was wrong, right? This is saying that Lincoln was wrong by Dred Scott. So this was a very important case. I want to walk you through the facts of the case, because most people don't understand it. Most people simply say, oh man, the Supreme Court said integrate the schools, and Eisenhower sent in the troops, and that's not what happened. It was actually a lot more complicated than this. So who's Cooper, who's Aaron? Okay. Cooper was a school board director, and Aaron was a parent of an African-American student. Okay? So here's what happened. Okay? A district court in Little Rock ordered that Central High School, which was a huge high school in Little Rock, has to integrate. Okay? But at the time, Arkansas had a law in the books saying that schools shall not integrate. So a state court issued an injunction saying you cannot integrate. Let me say this again. A federal court said integrate, and a state court said do not integrate. Everyone see what I'm talking about, right? What's to be done when you have a federal court saying one thing and a state court saying another? Well, you may say the federal court, of course, is supreme. Says who? That's not written anywhere. So we actually had were dueling injunctions from a state court and a federal court saying do the opposite thing. Okay? Eventually, what happened with this case is that a lot of these students were being denied entry. And President Eisenhower sent a telegram to the governor of Arkansas saying, you need to follow the federal court order, not Brown, but the order from the judge in Little Rock. The governor of Arkansas said, wait a minute, I'm not bound by that judgment, right? Who was bound? Cooper. And Cooper was a school board director. He said, look, I'm not here. So the governor actually sent in the state police to deny entry to these African-American students. Were they violating a court order? Technically not, because they weren't part of it. Then what happened? Follow me here. The judge said, fine, I'm going to enjoin the state police. So what happened? The Little Rock police showed up. See what they're doing? It's like whack-a-mole, right? You enjoin one, the next one comes in. Then the local police came in. Eventually, Eisenhower said, screw this, this is not how you respect courts. I'm not working with this. So they sent in federal troops to escort the students into the building. These are called the Little Rock Nine. There were 9 African-American students who were escorted in. And just like, look at this picture. They're walking into the school with guys with rifles in their backs. This is a very iconic picture, which I'm sure you've seen before. This is another picture, and just take a look at the girl over there, and just the way she's screaming and yelling at the student. There's actually somewhat of a happy ending. Eventually, these two actually met again. She apologized. It was actually it was touching. They actually figured who the girl was. I mean, she, what did she look like? 17, 18 years old, right? But she said, like, I was an idiot. I'm sorry, and she came around to it. I think I read this recently. There's only one member of the Little Rock Nine. I think she turned 90 recently, or 80. She recently had a big birthday, so it was a big story. This is Governor Orville Faubus, has a newspaper, and the website says, Guns Force Integration. If you ever go to Little Rock, which I encourage you to do, visit the school. It's pretty nice. They actually, they took an old gas station across the street and they restored it to how it would have appeared in the 1950s. It's like a little museum. It's actually, I spent a couple hours with it. It was actually a lot of fun. But the weird part is, it's still an active high school. So this schmuck, I'm walking around taking pictures, and I feel like such a creeper. Like, this is almost like I got arrested for taking a picture of the Kilo home, but I'll give that one away. So there's a case in property which you study, or you will study, called Kilo v. City of New London. It's an eminent domain case. And effectively what happened was the town of New London, Connecticut, wanted to use the power of eminent domain to seize a woman's house. And they were basically going to give it to Pfizer so they can build this massive, research facility. So I was in Connecticut, and I was like, let me go there. And I wanted to take a picture of the site that was taken. I had read that the site was taken over a decade ago. It's still an empty lot. So I'm driving around with my camcorder. This was a couple years ago. So I'm driving around with my camcorder, just zipping around the town, and I make a wrong turn, and I accidentally pull into a parking lot for General Dynamics, which is a military contractor. I'm like, oh crap. And this guy in a Jeep pulls in front of me, and he gets there, he's like, what are you doing? And I'm like, oh god, this would be bad. And I'm like, I'm a property professor. I am taking a picture of a famous Supreme Court case. He didn't know what the hell I was talking. He's like, give me your license. I'm like, oh crap. So eventually I told him, I'm like, look, I'm going to delete everything on my camera. I'll show it to you. Just let me go. And he eventually let me go. But I almost got arrested for taking pictures of a Supreme Court location. But it was worth it. I went back and took other pictures outside the parking lot, which is why I didn't really care. But the point is, this is an active high school, and if you just go there, it's humongous. And like, I walked up those stairs, and it's like, it was a strange feeling walking up those steps with this sort of history that went there. It was very weird. So if you ever go to Little Rock, I encourage you to just take the trip. Here are my pictures. School was in session. I felt like an absolute creep. Well, no one was playing hooky though, so that's actually surprising. Anyway, what was that? What was it? Oh, sorry. Yeah, I keep hearing you.
Not with a guard like that, I wouldn't either.
Yeah, Zach.
So are there teachers that refuse to teach?
What do you mean?
Did they have to force the teachers to teach them?
No, and actually the irony is, at the time, the school board wanted to integrate. The teachers wanted to integrate. The problem was the governor, who kept sending up police to block kids from entering the building. In fact, I think I read somewhere that on the first day of class, the Little Rock Nine stayed in the principal's office to avoid getting lynched. Right? They didn't let them go to class for the first day. Eventually, the commotion died down and things quieted, but it was a big to-do. But that's the background for Little Rock, for Cooper v. Aaron, right? You had these efforts by state officials saying, look, we're not bound by this judgment, we'll send this police department, that police department, right, to try to deny entry. But eventually, what happened was this case made it to the Supreme Court, okay? Why? The district court judge granted, I think, a 3-year extension to the district to integrate. They said, look, I'm going to give you 3 more years to integrate, you need more time. And this was appealed up to the Court of Appeals. And the Supreme Court took it. And the Supreme Court acted very urgently. I think it was argued in August and decided a few days later. The reason why was the school year was beginning. And the justices had to get their opinion out before the school year began, right? But the decision itself is significant for how it articulated the role of the Supreme Court in our system, okay? The other important aspect of this case is that it was signed by all 9 justices. That had never happened before. You'll see opinions where, Justice so-and-so writes majority and he concurs and he dissents, right? But here, all 9 of them signed it. That's very rare. You don't see that very often. I haven't seen it since then. Okay, who am I up to? Rosario. So, describe for me the court's analysis in Cooper, please. I gave you the facts. I did the hard work. Most of the facts weren't in the book, so I have to give you the outside stuff. Go for it. Good. So, what did the court say about the power of their own jurisdiction? What was the effect of Brown 2? What was the effect of Brown 2? After Brown 2, was there any need for the district court in Arkansas to issue subsequent orders against the school district and police and this and that? Wait a minute though. Adiami, wasn't the entire point of round 2 saying we're not going to supervise this all at once, we're going to let the district courts manage on a case-by-case basis? Isn't that what we just said 2 minutes ago?
That's what they decided in round 2.
But then what happened?
Oh, that was the last sentence.
That was the last sentence. But then what happened, right? Let me explain this again. In round 2, the Supreme Court said, are we going to supervise this by ourselves, or are we going to let the lower court do this on a case-by-case basis? And what did they say?
Case-by-case.
Okay. What are they saying now, though? Sorry, I said it a minute ago.
That everyone's bound by it, not just the parties involved.
Yeah. Right? So Jay replied, right, 2 minutes ago. This case only affects 4 jurisdictions: South Carolina, Virginia, the DC, and Kansas, right? But now they're saying, yeah, that didn't work out so well, right?
Right.
That did not work out so well. And as a result, we're making this new ruling. And under this new ruling, everyone will be bound by round 2. Whether or not you've been sued, right? Whether or not there's a judgment against you, you are now you are now bound by this. You're brown, right? You're it's making a verb. You are bound by this judgment. You're bound by the judgment in Brown 2. Now, why, Lacey? What do you think changed between Brown 2 and Cooper that they sort of pivoted to this new direction?
They're taking their sweet time.
They're doing more than taking the sweet time. What were these jurisdictions actually doing?
Resisting?
Yeah, they were resisting, right? This was the massive resistance. And the way they were resisting is by saying, okay, you sued me, I'm going to stop misbehaving, but then he's going to do it. You have to sue him, and you have to sue him, and you have to sue her, and sue them, and sue them. In other words, they were going to make it virtually impossible because you have thousands of concurrent lawsuits across the country, right? This is just Little Rock. All the states had probably hundreds of school districts. And each separate school district would then be required to litigate over and over again. So what the Supreme Court basically said is, screw this, right? This is not working. We said, with all deliberate speed, this is ridiculous. Now, I think we can all agree as a practical matter that makes sense, right? It doesn't make any sense for the same issues that can litigate 100,000 times across the country. But the harder question is, was this case correctly decided? Could the Supreme Court actually bind parties? Jay said it 2 minutes ago, right? She said, remand to these 4 district courts. Right? You learned this in civil procedure. Remember personal jurisdiction, service of process? You can't sue someone until you serve them process, right? That's like black letter 101. If you're not served notice, you're not bound by the judgment. You weren't. If there's ineffective service of process, you're out. You're good. You can even challenge a judgment after. Like, look, they never told me. I didn't show up in court. I had no idea. But this decision basically carves out that principle, saying because we're the Supreme Court and we announce the supreme law of the land, everyone everywhere is bound. Jessica, what's your reaction to that? Is that right? Is that wrong? Or is it just necessary for this, this sort of?
I think it's necessary.
Yeah. Is it right or wrong as a matter of law? I don't know. What do you think? Yeah.
Probably wrong.
Maybe want to say it's right? Yeah, Andrew.
Could you repeat the question?
Oh. No. I'll come back to you. Jonathan, is it right or wrong? Okay, why?
Brown was already like narrowed to just public education, so you're applying it. So.
All right, let me answer this question. I'll come back to Andre now. Should it have come as much of a surprise to Arkansas that they're going to have to integrate their schools after Brown?
I think that they knew they were going to get dragged kicking and screaming doing it.
They knew it, yeah.
Yeah.
So is it then unfair to make them be bound by the Brown decision?
I don't personally think it was unfair.
Yeah. So this is one of those cases where it's probably wrong as a matter of law, but as a matter of fairness, it's probably right. Martin said it's the right thing to do. Adiana, you want to add something?
I was just wondering. To me, I saw more of the Supreme Court saying, being bothered
Like a testosterone challenge, I hate to like gender.
Do whatever
that
you want.
way, But categorize it that way, but more of a, you know, like a power challenge, like I'm
Oh.
anything you can do, I can do better.
So you're
they
saying-
said, and they're like, no, you can't.
So let me see if I can repeat what you just said. You're saying that the southern states are basically challenging the Supreme Court's authority, right?
Yeah.
And they're saying, no, you will not.
Right. And they shut it down. They're like, well,
Respect
you know what?
mine.
Now everybody's got respect mine. Right.
Exactly. Yeah, the Eric Cartman School of Constitutional Law, right? Right.
So were the courts not relying, or the southern states not relying on Plessy?
On what?
On Plessy?
Well, let's go back to my first question today. The southern states said Plessy was still law.
Well, then why are they attaching that to them if they weren't parties
Because
to
they
that
said
law?
Plessy was correctly decided, right?
What do you mean?
They said that Plessy was correctly decided and that Brown was wrong. And that Brown made it up. And again, when you read Brown, was there much legal analysis there? There wasn't.
Why would they be attached as if they weren't parties to the
Because-
lawsuit, then why would they think it applied to them any more than Brown didn't apply to them?
They didn't. They thought that Brown itself was illegitimate because it was wrongly decided. The opinion had no analysis about social science, right? They're saying that Brown can't bind us because it was wrong. That was another layer of the resistance, right? That Brown was wrongly decided, therefore it can't possibly bind us.
So what about this would be bad? I don't understand why you think maybe it was bad law.
Well, no. What they said was, if you read Brown, there's no analysis, right? It's just all social science stuff. They're saying this was a made-up decision. Plessy was decided within 15 years of the ratification of the 14th Amendment. That was an accurate statement of law. Because Brown is wrong, it can't bind us. It was actually an argument this case is wrongly decided, right? In the same way people can say that, you know, maybe the Citizens United case was wrong, we're not going to follow it. Or the DCV Heller case was wrong, we're not going to respect it. They're saying Brown was wrong.
But I understand why Brown didn't rely on Plessy to end segregation, but there were other district courts that did rely on Plessy to end segregation in schools, like Mendez versus
You talking before Brown or after Brown?
before Brown. So I just, rather than giving them the option of saying, like, I get it, they didn't want any dissents of that, but why not? Never mind.
Does a district court have the power to reverse the Supreme Court decision?
No, of course not.
So how did they do that? How did the district courts you mentioned, I don't know the decisions, but how can a district court reverse Plessy?
No, they can't. But they relied on Plessy to end segregation.
By saying that the schools were not equal. They were separate and not equal.
Right.
Right, but that's not saying Plessy's wrong, though.
No, I didn't say that.
Right.
But neither did Brown. They didn't say Plessy was wrong.
Well, they said it was wrong in the context of public education. They said separate cannot be equal. Be precise here, right? They didn't overrule Plessy overall,
Right.
but they said separate cannot be equal in education, public education.
That was kind of wussy of
Want to
them.
raise your hand, please?
Wasn't that kind of
No, you didn't raise your hand yet. Okay, now I'm calling you. That's real. If you want to speak, raise your hand. Yeah, go for it.
It's all right. I'm good.
Okay. Anyone else? Yeah, Aaron.
So, in Cooper v. Aaron, it's saying they basically decided that the Supreme Court decision was Supreme law, right? How is that legal?
What do you mean legal?
To me, it seems like someone just walked in and was like, "Oh, by the way, I can charge." Like, how are they able to give?
Well, no, let me defend it, right? This didn't just happen overnight. There have been 200 years of judicial review, right? So it's not like the Supreme Court was created and like, oh, let's do this thing. But what was new, and I think this is what your question is focusing on, is the idea that our judgment binds everyone, everywhere, in all circumstances. And what makes that judgment difficult is that just 3 or 4 years earlier, they said, look, we're just doing these 4 cases, we'll let everyone else figure it out. And I think the authoritative line is good because it's saying, this didn't work, right? In order to handle the thing of this monumental path of desegregation, they had to get a little desperate, right? They had to do something different they hadn't done before. Dave, was your hand up also?
Yeah, I was just going to make a comment about saying, like, you know, one district court can't necessarily rule the Supreme Court or federal law.
I don't think they can.
How come, like, we have such arguments today, can a district court have an injunction that affects?
What a good question. So the question was about nationwide injunction, which you may have read about, right? May I ask, what is a nationwide injunction? Usually a district court has only jurisdiction over its own districts. So a district judge in Houston could bind the Southern District of Texas, which is basically from here down to Brownsville, right? It's a pretty big area. But in recent years, judges have begun to issue injunctions nationwide, barring the federal government everywhere. There are lots of criticisms of these, and the argument is, how can one lower court judge effectively become a mini Supreme Court, right? How can a single judge bind everyone everywhere nationwide? It's an open question. I think the Supreme Court may actually push back on this, because if a single judge can set nationwide policy, respect my authority, I think it's a plan to the Supreme Court's jurisdiction, right? Jason?
Was it this time we were talking about before? It's how we comply. If, you know, when the Supreme Court says something, like in this instance, if you send in the National Guard, the executive branch is now supporting the Supreme Court.
Good.
And so because we comply and our law enforcement complies and we give consent through our systems of government that we have in place, that kind of is what's giving them that power.
Yeah, but did Arkansas complied? The Governor Favis in Little Rock, Arkansas, were they complying with this ruling?
The state government now.
No, they were not. So I think it's, in principle, you're right, but not everyone went along with this. In fact, if you, again, in the next book there's a picture of this, but if you were to drive around the South in the 1950s and 60s, you'd see a billboard that said impeach Earl Warren, right? These billboards are put up all over the place. And there was a strong sense that this was an awful, lawless action, and it must be resisted. And this went on for years. And I think Aaron mentioned this a minute ago. You still have, year 2017, school districts that are under federal supervision to integrate. Still, what, 50, 60 years later? Is your hand up? Yeah.
Well, my next point was, didn't this just same sort of debate happen with same-sex marriage, where states were resisting federal law? Isn't this still going on?
Which states resisted it?
Texas, for one.
How so?
I don't remember exactly what.
It's not in the family law code.
It's not in the family law code, and I think there were some counties that were refusing to stamp, marriage licenses.
So the issue here with the same-sex marriage decisions is how long it took to comply, right? I don't think Texas hasn't updated its family code, though it's basically judicially updated at this point.
Well, no, they just had a voting year. It came out with a new family code. It's not in there.
Yeah, but it would be unconstitutional to apply otherwise. So it's basically judicially updated at this point.
Okay.
But the point is, as it stands now. All right, let me do it like this. I got to explain this. Is anyone following the case Pigeon v. Turner? You know what this case is? So before Obergefell was decided, right, before the Supreme Court ruled, Mayor Parker, who was the mayor of Houston until a couple of years ago, announced that city employees who are in same-sex relationships would get benefits, right? Under Texas law at the time, that was illegal. Because under Texas law, there you go, Kate, bring it back up, yeah? Because under Texas law at the time, it was illegal for the state to recognize any same-sex unions. Okay? So if some taxpayers in Houston sued the mayor, under Texas law, taxpayers can actually sue. It's a very strange thing. But under Texas taxpayer standing law, they sued Mayor Parker, and now Mayor Turner. And they argued that she's breaking the law. Okay? Subsequently, Obergefell was decided. Okay? And after Obergefell was decided, there was a case by the Fifth Circuit called De Leon. And the decision in De Leon, Fifth Circuit case, they said that the governor and the attorney general and a few other officials can no longer enforce Texas's marriage law, right? So notice what I just said. De Leon only involved a lawsuit against the governor, the attorney general, and a couple other state officials. Was the mayor of Houston party to that case? No, she was not. So this came back to the Texas Supreme Court in a case that made a pretty big stir over the summer, which a lot of people don't understand. As it stands now, the Texas marriage law is still in the books. I think Aaron and Kevin mentioned a minute ago, right? The Texas Defensive Marriage Act is still in the books. The governor, the AG, and a few other state officials are barred from enforcing it, but it's still in the books. As it stands now, is the mayor of Houston still bound by that law? The uncomfortable answer is probably yes. And if the answer to that question is yes, then Houston's breaking the law by providing benefits to couples. So this has been challenged in other courts, and in fact, there's actually a cert petition pending. But this is a really big case, which I think could be a follow-up to Cooper v. Aaron, about whether Bergefell not only struck down all marriage laws nationwide, also required cities to provide marital benefits to same-sex couples, right? How far does a Bergefell reach? This is a very difficult question about the scope of judgments and who's bound, right? If you just read the headlines like, oh wow, Supreme Court, Texas ignoring the Supreme Court, it's actually a little more nuanced than that, of who's actually bound by the judgment, and whether people who are still bound by Texas's marriage law can violate it. Because in theory, a state court today could hold Mayor Turner in contempt for violating Texas's marriage law. It's not going to happen, but the law is still in the books. Right? This is a point people don't quite get. We say the court struck down a law, right? Does that mean the Supreme Court of Texas or the U.S. Supreme Court took a knife and actually removed the page from the Texas Code? No. Right? Courts can't strike down laws. They don't have that power to erase stuff. They can't erase it from the books. What courts can actually do is say, you can't enforce this law. If you enforce the law, I will hold you in civil contempt and throw you in jail. Right? Even today, Texas still has a sodomy statute in the books. It's still there. Right? Even after Lawrence v. Texas, there's a sodomy statute still in the books. The legislature never removed it. There's a little notation that said, I think, ruled unconstitutional by Lawrence, but still there. So it's actually not surprising they never voted to remove it. But if anyone in Texas tries to enforce it, well, what would happen? Who was a party, Lawrence v. Texas? It was actually Lawrence, and I think the Texas AG, and also the Harris County District Attorney. So I think Texas would probably be barred from enforcing it by the matter of judgment, but it's still in the books. So the issue of resisting, and this phrase that comes up a lot, is very specific. And again, if you accept Abe Lincoln, then it's not. If you accept Cooper, then it is. And Cooper is our law at this point. So we'll see what happens with the Texas case. But this is going to be a big case. I don't think the Supreme Court will take it. I think this goes back down to lower courts.
For the 5th edition, right?
Oh God, don't. I mean, the third edition. I'm getting the final proofs next week, so I don't want to think about it. I have to review all. It's the book's 1,800 pages. I just want to think that's a lot of pages. A lot of pages.
Should have made it so long.
Wise guys. All right. Anything else? Wise guys. Anything else? On Cooper. Right. So yeah, Andre.
Just as an extra. So these National Guard troops are just going to start shooting cops.
Well, I want you to think about this, right? The 101st Airborne show up, right? They're there with their rifles. The Little Rock police say, we're not moving, make us. Okay, what happens then, my friend? I want you to think about that for a minute, right? 101st Airborne shows up. They say, we're going to take these kids into school. The state police say, no, we can't. There's a law barring this. Go away. Let me ask you another question, right? What if Eisenhower never sent in the troops? By the way, Eisenhower did not favor desegregation. It was actually a wrinkle of his history, right? He didn't actually favor it. But what made him angry, guy as a former general, is that people were not following court orders. That was actually what set him off, right? He actually was somewhat ambivalent about Brown, if you look at his papers. But he did not like people ignoring court orders, which is why he sent in federal troops. Now, what if instead of having President Eisenhower, we had President George Wallace, or a segregationist, and didn't send the troops, right? What would that have done to the legitimacy of the courts if the court issued an order and these kids were barred from entering the building? Yeah. So instead of thinking about the hypothetical, what if they start shooting at each other, which I suppose could happen. The hypothetical I would ask you to think about is, what if Eisenhower said, I think the Supreme Court was wrong, plus he was right. That would have been a very different world. Yeah, Evan.
So, going all the way back to Madison and a couple of other cases we talked about, the courts have, I think, consistently said that they shouldn't involve themselves in the political process.
Yeah.
And you want the law to change, you go vote or you do other things. So, taking this case, could the Supreme Court now just say, well, we kind of use these other reasons, not really law to make this to to decide this case, can't we just do that? Or, I don't know, analogous.
Yeah, I mean, the Supreme Court injected itself in a pretty volatile area. And they did so as narrowly as possible. Which is, again, I think I asked this question 30 minutes ago, but I think to Alyssa or someone. If they had said this is not just public education, but everything, they said tomorrow, Jim Crow, adios, the entire thing's got to go, there'd probably been a civil war, right? They would have been bloodshed. What's going on there? Oh, okay. We're not doing that.
So, I mean,
Sit down, it's okay.
if they wanted to, for example, this is just hypothetical. If they wanted to say, okay, well, there wasn't any history law here, but gay marriage, let's say he had his court and say, okay, well, we think this is now right.
In the 1950s or today, you're asking about? Well, they did that a couple of years ago.
I mean, that's what they could just apply it to, their logic, anything they wanted.
Kevin?
Do you know why the 9 went down to with the?
I think one of them maybe just dropped out. Yeah, I don't know the specifics, but I mean, what was that?
Did you get expelled for foreign children or something?
Oh, you might be right. I think it might be a disciplinary action. I can't recall. But I mean, you can imagine being shouted down and spit at and cursed at. That you may not want to put yourself. I mean, these kids were 17, 16 years old, right? I don't think I was that brave when I was 17. I certainly was not. Anything else on Cooper? Anything else on Cooper? Let's go back to Bolling then. Bolling's so anticlimactic, right? Because you have these huge cases, and Bolling's like, Bolling was a case. I think I have a picture of Mr. Bolling up here, from the District of Columbia, right? There's a Spotsworth Thomas Bolling Jr., who was 12 years old, who wanted to attend a junior high school in the District of Columbia. So, who am I up to? Okay, yeah. Okay, you're up. So, why was Bolling v. Sharpe a little bit of a difficult case for the court to resolve?
Well, it was decided under the Fifth Amendment, which doesn't have an equal protection clause.
Yeah.
It has to go under due process.
Very good, thank you. So, Bolling was decided under the Fifth Amendment. Okay, why? The Fifth Amendment applies to the federal government, and this was a school in the District of Columbia. Brown from Kansas was under the 14th Amendment. The 14th Amendment expressly applies to the states. The 14th Amendment also has the key provision, the Equal Protection Clause. The Fifth Amendment does not have an Equal Protection Clause. Right? So Anthony, how does the court get around this? Right? How does the court, I mean, the court I suppose could have reached a ruling that segregated schools are unconstitutional in Kansas, but they're fine in federal territory. They could have done that, I suppose. How did they get around that?
Well, it seems like they just kind of added it.
Give me a little bit more than that.
So the equal protection laws is just more than just due process, and that it can be applied in situations.
Okay. Case, want to give a little bit more?
They used the due process clause of the Fifth Amendment. They said that it was basically depriving them of their liberty, and that the interest of the state in segregating schools was not valid enough.
Yeah. So this is what you might call a fudge, if you will. They had to make it work. And the way they got to make it work is a strange thing. So we've discussed what's called the Incorporation Doctrine, right? The Incorporation Doctrine. And this is a notion that the Bill of Rights, the first 8 amendments, are incorporated into the Due Process Clause, that the liberty interests protected by the Due Process Clause are free speech and free exercise, etc., right? Incorporation, which I think makes some sense because the 14th Amendment came after the Bill of Rights. The Bill of Rights was ratified first, applies to the federal government, then some years later the 14th Amendment came along, and you incorporate the Bill of Rights into the 14th Amendment. Bolling v. Sharpe does the opposite. This is what's called reverse incorporation, a very strange phrase. Reverse incorporation. What does that mean? That the word liberty in the Fifth Amendment embraces the Equal Protection Clause. Let me say it again. The word liberty in the Fifth Amendment embraces the Equal Protection Clause. That is, the 14th Amendment, ratified in 1868, modified, updated the Fifth Amendment, ratified in 1791. Say it again. The 14th Amendment basically updated the Fifth Amendment. Okay. There's no evidence this is actually the truth, right? There's no evidence this is actually correct. It's probably made up, once again. But the court basically had to go there because they said it would be absurd. It would be absurd to have a different standard for the federal government than for the state government. In other words, you need to have the same standard for both. Carlo, is that... I'm sorry, Brittany?
I'm sorry, can you give that word, the word liberty in the Fifth Amendment?
Embraces.
Embraces.
Yes. Carlo, is this insane that you'd have different standards for the state and the federal government for equal protections? Is that really so crazy?
No.
You say no, why not?
Well, because, but,
would it be unthinkable that the framers of the 14th Amendment would impose a different standard on themselves, Congress, than on the states? Was that unthinkable?
no, because
Why not?
The states, they have their own enumerated powers and the things that.
What was going on in the 1860s that may have said to Congress, maybe we should give a more stringent standard for the states than for us?
Civil War.
And then?
Back a bit.
And then what? What happened afterwards?
Emancipation.
And then after that?
Had the progressive.
Oh, he skipped the state.
Reconstruction.
Reconstruction, right? So there's an argument, right, that the framers of the 14th Amendment would have said, Congress is not the problem, right? We don't need to be bound by an equal protection clause. The problem is the states, because they're making all these Reconstruction Jim Crow stuff, right? So it's conceivable that there could be two tracks, right? One track for the federal government and one track for the states. The Supreme Court of Bolling rejects that. So as it stands today, the state governments and the federal governments are equally bound by the Equal Protection Clause. Let me say it again. As it stands today, the state governments and the federal government are equally bound by the Equal Protection Clause, even though it says state, because of this reverse incorporation doctrine. Yes, sir.
And so there was some part of this case that was basically saying that you could use due process if it was such an egregious, problem that it was really affecting their liberty.
Uh-huh.
So are you saying that with the the federal government and the states are equally bound by the Equal Protection
Yes.
Clause? Does it need to not even be egregious anymore?
No.
Okay.
And let me ask a different question, Kevin. Kevin, if segregated schools violates the due process clause, right? It's a violation of liberty. Why in Brown did it even need to turn to the Equal Protection Clause, right? If it's a violation of liberty by itself, that it's an unreasonable regulation, why do you need to bother going to the Equal Protection Clause in Brown?
Because the Equal Protection Clause applies to the states.
It's there, but my question is, the 14th Amendment also has a due process clause, right? Why couldn't they just apply Lochner and say, look, it's an unreasonable regulation to have segregated schools, makes no sense. It's not within the police power. Why do you even need to go to equal protection?
Because the Equal Protection applies more to racism.
But could you, if Bolling v. Sharpe came out the same way as Brown, and Bolling did not rely on the Equal Protection Clause, why couldn't Brown come out the same way? Why couldn't Brown be a due process case? Is there any reason why he couldn't?
Because the Brown case was a public school, whereas the Bolling v. Sharpe
Public school also.
But wasn't DC more? DC was not a state.
No, it wasn't.
So DC, the 14th Amendment applies to states, whereas the 5th Amendment applies to.
Yeah, David, see what I'm getting at here? In other words, was the Equal Protection Clause even important to the decision of Brown? Could they have reached it just under due process?
I think it's because it's a separate but equal issue.
Well, they have to tackle Plessy, but the question is this. Did the Brown court actually need the equal protection clause to get to the result in light of Bolling?
No, they could have, I guess, used the liberty.
There it is. Right. The Bolling case basically proves why the Brown analysis is unnecessary, right? If you can get where you need to go with the word liberty and say this is an unreasonable regulation, you don't even need equal protection. You did not even need to overturn Plessy. It wasn't necessary. Because Plessy was an equal protection case, you say, aha, but due process, additional. Aaron.
On that word liberty, they use the term, what is this, proper governmental objective, like it can't be restricted other than proper governmental objective.
Yeah.
What does that mean?
What case does that remind you of? What sort of cases that assessing the government's motivation for these studies that reminds you of? You know the name. Called Bread.
Oh.
No, not Dred Scott. Lochner. Bread. Oh. You're sitting the closest to me also. That's 1 ear. You're 5 feet away from me. Okay. Bread, not dread. So bread, right? Lochner.
Right. The sort of due process analysis here is very much like Lochner. It's like Buchanan v. Warley, saying that the segregation ordinance in Louisville makes no sense. This is substantive due process, right? It's a substantive due process case. This is where liberty has substance, and this is unreasonable regulation as determined by the courts. So the fact that Bolling got to its answer with substantive due process makes you think, why do you need equal protection? Right? Is it even necessary? So today, whether or not you can justify Brown as a matter of originalism, and I think there's some good arguments you can, it's very hard to justify Bolling because it has a feeling of this like, oh crap, what do we do now, right? We really have this where we're allowing segregated schools in the nation's capital. We can't have that, so let's do this thing. So it's a very hard to justify opinion. Yes, sir, Jason.
Wasn't it kind of like they had no choice? I mean, the question earlier, what were the airborne soldiers going to do? Were they going to shoot anybody? Well, the reality is there was Arkansas had one option: comply with the federal government or
what?
Civil War, right? I mean,
yeah,
that's you know, how far do you want to take it? And so, how can the Supreme Court tell the states you have to do something you don't want to do, but we're not going to do it?
Well, again, if the Supreme Court ordered the governor of Arkansas to desegregate the schools, he said no, and then Eisenhower can send federal troops.
No, right, but in this instance, they have to have some idea of what's going on politically. I mean, we talked about before that the courts haven't made certain decisions because they didn't think that it would be enforced. And so, if this is during a time period where the court
didn't know what Eisenhower would do. They didn't know in advance. Eisenhower could have said, "Screw this! I don't need to focus on other things right now. I want to get reelected in a couple of years. I need the Southern vote." Right.
But I guess my question is, how could the court have ruled differently in Bolling, knowing that that's not how they would rule in a state instance?
Well,
because then it seems almost hypocritical, right? You're telling a state you have to do something that you don't want to do. That's the law, but the law is not the same for us. We can do whatever.
I think they could have held that, but they didn't. Other questions on Bolling? All right, so Bolling is at bottom a substantive due process case, right? It's saying that this is an unreasonable law. It's an arbitrary violation of liberty, and under sort of Lochner-style analysis, we're going to strike it down. You may even think of footnote 4, which was not cited, which could have been cited, that this law affects discrete and some minorities, right? Keeping kids out of school. They could have said that because of footnote 4 that this is a supported case for substantive due process. They didn't do that. They gave this really weird analysis that confuses students every year, which I have to basically explain it to you. But that's what they were doing. Any other cases on Cooper? I'm sorry, not Cooper, Bolling. Any other cases? Martin, your hand up or no? You thinking about it?
Does the Supreme Court have to give an analysis, or can they just say it is so ordered?
Oh man.
I feel like that's kind of what they're doing here, and they're just looking for ways to justify.
Just by fiat, saying because we are 9, we order.
Yes.
Right. So it is. You ever seen the movie Gladiator? Mm-hmm. Right. You know this scene where the emperor goes thumbs up or thumbs down. Right. Thumbs up, the guy lives. Thumb guy. That's what I feel about Justice Kennedy. Right. You know, he basically says thumbs up, thumbs down. There's a lot of stuff there, not much analysis. Yeah. If they just said we determine that the school segregation is bad, reversed, which is what you said, it's not right, would that be any different? In other words, what's the reason why judges write these long opinions? Brittany said it was short, right? Why do judges write long, thorough opinions, Martin? What's the purpose of, other than to torture law students, but why do they write long opinions?
I mean, I feel like it's just so that they don't get questioned as often.
Well, not just get questioned. Why do judges wear robes? Why do they write these long opinions, right?
People believe.
Say it again?
So people believe them, or at least don't argue.
Well, one at a time, please, one at a time. Ashley.
Authority?
What do you mean authority?
I mean, it's, so, the reason why they wear robes is because it's a figure, like it displays a position of respect or a position of authority.
When judges are wearing robes, do they look different?
Yeah.
Oh.
Yeah, I mean, they do. Like
Different from us, you mean?
Oh. Like
among themselves, from one judge to the other, they're all wearing robes, right? You see 9 people in robes up there. The reason why judges wear robes, I never thought about this, is to separate them from the personalities. They all wear the same thing, right? The same black robe. And they're all the same. And they basically separate those. Why do priests wear the collar, right? Why do people wear uniforms? To separate their personal from their profession. That's why people wear uniforms. It's much the same way with judges. The reason why they write long opinions is not to bore you. The reason why they don't do what Martin said, just thumbs up or thumbs down, is say, look, this is not just me, right? This is not just Anthony Kennedy making crap up, right? This is law. There is reason. There is analysis. We're giving you rationales that you can apply in the future. This is separate from the individual. So to answer your question, Martin, I think it's a good question, is if they just say thumbs up, thumbs down, right? Judgment for plaintiff or judgment for defendant, no one will buy it. Say, this is garbage, right? There's no reasoning here. But when you give a reasoned opinion, it's like, oh, well, I lost, but that makes sense. But what happens when you give a 12-page decision that makes no legal analysis and cites some social science articles, right? It's like, what the hell is this? So you all know learned Hand, right? The Hand formula, right? He was one of Brown's biggest critics. What do you mean, Brown had critics? Oh yeah. It was widely criticized as an act of judicial abuse in the 1950s, right? It was basically saying, the court's making this up. This is not law. And Judge Learned Hand today is revered. But he was saying, this opinion's terrible, right? Segregation's wrong, but the court has no analysis. They just make stuff up about Dahl tests, whatever other study was done. So, again, to your question, Martin, why do they give this analysis? So it looks legitimate. But when they give an analysis that reads like garbage, what do they say to people studying it? It's like, well, maybe it's wrong. Right? Having a unanimous decision that makes no sense may actually be worse than having a 5-4 decision that does. I don't know. Right? If you had a 5-4 decision that, Plessy was wrong, was decided, overruled, equal protection means equal protection, done. That would be a very different story, which people say, well, I disagree, but there's some law there. This is, I don't know what this is, it's whatever. Emily, your hand was up a minute ago?
Yeah, that just reminds me of the conversation we had in Plessy that courts don't enact, or rather rule on issues that the public might not be ready for.
Ah.
So,
yeah, so give me a little bit more on that.
Well, basically that's all I don't know, from
Plessy.
Plessy.
Oh, that's very good.
But my thinking is, the analysis in Brown being so different, I guess, based in social science rather than legal, than law.
Yeah.
It just seems like the justices had it in their mind what was right, like Martin was suggesting, and that they, I don't know, I guess they figured the society was ready. It was time now, 50 years later after Plessy?
Yeah, more like 70 or 80, yeah. Maybe she's right. Maybe the justice said it's time and we don't really need to give a reason, right? That it's so self-evidently true that this is correct that people will just accept this reasoning. They were maybe naive about that because it was not the case.
Yeah.
Now, even if the court had done the 5-4 decision where we say Plessy's overruled, the reaction would have been exactly the same in the South. Right? Don't pretend for a second it would have made a difference. But we're studying this case 7 years later, reading in a nice classroom, right? It has a very different vibe. So maybe they said, this is the best we can do to get 9 votes, and let's go with this. So any other cases, we'll do Loving in a minute, but any other cases on Brown 2, Cooper, Bolling, other questions in your mind? Right, these are important cases, not just for equal protection, but also the power of the courts. These are among the most important cases to read all year. Jason?
Do you think that the role of the court started changing in that, in response to how difficult it is to make legislation?
Yeah, I do. I think that this desegregation movement profoundly changed the way the courts operate, without a doubt. Yeah, Adriana?
This is more of an opinion piece, but I saw that these last few weeks there's been a great emphasis on education and how providing everyone an equal education, equal opportunity to a proper or well-established education forms our country and helps us develop and puts us at the forefront, within the world. But I feel like that's not really the case or the theme now. Would you?
You're way outside my pay grade. I can do law stuff, I don't do policy. I don't know, your point sounds stupid, I'm not really sure what the answer is.
I'm sorry, can you repeat that?
I don't know how to answer your questions beyond my expertise. I'll do law stuff.
I was a teacher.
Oh, wonderful. I love teachers. Anything else on Brown or Bolling? Or
I didn't
Cooper?
need to finish my question. That wasn't the end of it.
Oh,
So
keep
I
going.
was
I'm sorry, I cut you off.
off.
Go on, finish your question. I'm sorry.
It was just a matter of, is there anything placed forward now or in the works now in regards to law or case law that addresses similar situations now?
Oh, I can answer that question.
Yeah.
So there's actually, some states have constitutional provisions which guarantee equal and appropriate education. There's different language along these lines. And states to varying degrees have had litigation over this. And there's actually a case in Connecticut now where basically one lawyer is trying to get the judiciary to take over the state school system and say that the schools have not been equally treated and just basically have judicial supervision of the education. That may sound amazing, but it doesn't work very well. Right. And in New Jersey, they've had this for decades, whereby this court decide what the school budget should be. It sounds fantastic. It's been an absolute disaster. Let me move on to Cooper. Loving. Can I answer the question later?
Yes, no, it was only a question, was a comment about that, is, looking at UT, which has done this sort of reverse discrimination thing, looking at accepting people based off of them being a minority, and I think it's in the Supreme Court right now being decided.
Well, it was decided a couple years ago. We'll get there in a few weeks.
Okay.
So let's do Loving. So, Loving, did anyone see the movie, by the way, Loving? Very good movie. I usually don't like Supreme Court movies. I like this one. Usually they're terrible. This one was actually pretty accurate. So go watch it. I put the trailer somewhere below. You can go watch it later. Yeah, I think it's on demand now. It's on Google Play. It's on iTunes. You can go download it. So it's a good movie. The only thing that drove me crazy about it, one thing, the scene where they go to the Supreme Court, they get out of a cab, and the cab pulls up, and across the street from the Supreme Court is like a residential neighborhood. Across the street from the Supreme Court is the U.S. Capitol. So I was actually screaming. I was very angry.
Behind it, though, is the residential neighborhood.
That was not the side they were on. No, but the side they walked into. But you're right. There are residents. That's not what they were. The other thing, there's another movie, The Woman in Gold. Anyone see that movie? With Ryan Reynolds, I think. It was about a Supreme Court case involving stolen Nazi art. They had a scene on the Supreme Court where there was a fan next to Justice Breyer. There's no fan on the Supreme Court. That's not how it works. I was very angry. So, any producers, call me. I'll make your movies authentic. But the case in Loving, right, involved interracial marriage, which is called miscegenation. And I actually mentioned this case a week or two ago. We did Buck v. Bell. right? That was the case involving eugenics. And remember I told you, I said the same law that created the sterilization law in Virginia also created the anti-interracial marriage law that they were arrested for. The facts here I'll give are actually very, very sad. If you watch the movie, you'll see this, but Mildred and Richard were in love, and they were married in the District of Columbia, and D.C. allowed marriage between black people and white people. When they returned to their home, which was in a fairly small county in Virginia, this was an awful scene in the movie, you can watch it. They were basically arrested in the middle of the night. The cops showed up with dogs and everything else, knocked down their door, and arrested them. At the time, Mildred was several months pregnant. And they let him go the next morning. They kept her for the full weekend. And I think they deliberately arrested her like on a Friday or something so that she didn't make bail till Monday morning. Right, she was there for the full weekend. The judge sentenced them to time in prison unless they left the state. And they promised not to return. So they went to go live for some years in the District of Columbia, but eventually they missed their home and they decided to return home back to Virginia, even in the same place. When they came home back to Virginia, they were basically in violation of law. Now, generally, when you have a criminal conviction, you have a fairly limited time to appeal, right? They never appealed their conviction. Instead, they filed a motion, which is basically a habeas corpus motion, saying that their confinement was unlawful, and they managed to challenge it in court. And this works their way up to the Supreme Court. Now, at the time, there were decisions that upheld interracial marriage bans. Here, the Supreme Court reverses those decisions, right? And, where am I? Evan, describe the court's analysis for me.
Well, I think the main thing is they recited the Supreme Court of Appeals for Virginia.
Good.
They recited a case called Naam.
Good.
And it basically is like some of the cases we studied last week, where there's two tests they were run, which is basically the first one is the state had a legitimate purpose for it, and the state was arguing that they wanted to preserve the racial integrity of the citizens, and stuff, other stuff like that, like corruption of blood. They mentioned it's
What was the state's interest, Evan, in having marriage segregated? Why would the state do this?
Well, I think what they mentioned is a doctrine of white supremacy. Like you mentioned, eugenics. They thought, I guess they were.
Yeah. I mean, there's not much of a mystery there, right? This was designed to promote white supremacy. If you prevent the interbreeding of the races, you keep the races separate, and you keep the white blood pure. There's not any other way to sanitize it. If you actually want to listen to something astounding, listen to the oral arguments in the Supreme Court. You can listen to them online. A website called OYEZ. They actually recreated the arguments in the Loving movie, which I watched. They got them correct. They actually, usually when they do oral arguments in the Supreme Court, they modify the transcript, which drives me batty. They actually got it accurate with a couple of variations. And one of the lawyers for Virginia basically argued, why do we need to separate marriage? Prevent interracial children. Okay? Why? The government argued, it's unfair to bring a child into this world to be of mixed race because they'll be ostracized. And they actually said that they were protecting the children of Virginia from the stigma of being an interracial child. That was actually the rationale. That they didn't want these children to come to the world because they'd be ostracized and they'd be separated from society. So Evan's right, the court invalidated this law, right? But Adam, what exactly about the law made it unconstitutional? Why? The law applied equally, right? A black person could marry a white person, and a white person could marry a black person. Why is that not equal protection? Everyone's protected equally.
Well, it went against the ideas of liberty and freedom.
Equal protection, that's what the word says. Why is it equal protection? Liberty and freedom is a nice word, but I want equal protection. Brandon, why is this a violation of protection?
I mean, for the same reasons, you you can't discriminate based on race,
Says who?
says the court.
Where do they say that for?
I mean, they make that determination in Brown.
Did they say that discrimination was always impermissible?
Well, in the last case, they subsumed that idea into the due process law.
Did either Brown or Bolling extend beyond public education? No. So Amber, how does the court go about finding that this statute is unconstitutional?
Korematsu.
Wait a minute, Korematsu. The government wanted Korematsu, right? They were allowed to uphold the Japanese detention ban. So how is Korematsu the precedent here?
Talks about most rigid scrutiny when it comes to race.
Oh, so here's a preview, right? We'll get this later. Even though in Korematsu the government prevailed, they announced this idea of scrutiny, what we'll later call strict scrutiny. And what strict scrutiny means is that when you have a classification on the basis of race, courts will look at it extra stringently. And if the reason given by the court's estimation is not legitimate, they'll strike down the law. And that's exactly what happened here. The court said in no uncertain terms that white supremacy, not a legitimate state interest. I'm skipping due process, I'll get back to it another time. But that white supremacy is not a legitimate state interest and does not justify the racial classification. So therefore they strike down the law. And oddly enough, they're citing Korematsu, where the Japanese internment was upheld, right? Remember that. But here they say there's no legitimate purpose independent of racial discrimination which justifies the classification. This was designed to maintain white supremacy. And with that, the law is struck down. The due process analysis, though, is very brief, maybe a paragraph. And what they effectively say is that there's a liberty interest in marriage. They say the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. Why is marriage essential to the happiness of free men? They're talking about reproduction, right? In other words, if people don't reproduce, civilization's over pretty quick. So here they're saying that this idea of procreation is so closely tied to marriage. That part falls out when we get to same-sex marriage. They omit that part of the Loving decision. But here the due process analysis is very closely tied to reproduction. It's fundamental to our very existence and survival, the court says. Right? So the holding then in Loving, and this is getting into a topic we'll continue next, is that when you have an equal protection case, you have to ask yourself, what sort of classification is there, right? How are they separating people? Are they separating people based on their race? Are they separating people based on their gender? Are they doing it based on maybe age, height, weight, education level? And depending how the government separates people, a different level or scrutiny of analysis applies. And that's what we're talking about for the next couple classes. Emily?
Is that from footnote 4 in Carol?
It starts with footnote 4, but it's a little bit different than that. But it's the idea that depending which people are implicated, whether it's discrete and some minorities, the law is different. Okay? So to summarize everything from today, although the court didn't actually kill out Plessy, they began to bring in this new framework under the Protection Clause, depending which people were separated and what the rationale was given for that separation, the courts would assess it under different levels of scrutiny, with magnifying glass. So questions? I will see you on Tuesday. Thank you very much.